Shikha?
Yes, sir. Audible.
Okay, great. The thought process behind having this topic for giving some insight on how the market has behaved post introduction of IBC was this, that I understand most of the members at ISCC are solvent entities and diligent insofar as their finances are concerned. But for this legislation where you could be exposed to certain contingencies as regards what happens with whom you have been dealing. It could be your vendor, service provider. It could be a JV company where you have minuscule role insofar as the regular operations of the company is concerned. Or it could be an investee entity where you have invested, but since you don't have control over the entity in its entirety, you are getting exposed to understand what IBC holds for you as a fellow shareholder, or for that matter, a service recipient, and so on and so forth. So I'll just present my deck, and for the time being, I'll just stop my video to ensure that connectivity is not lost out. Just allow me 5 seconds. Shikha, would you be able to confirm if the screen is visible?
Yes, sir. Screen is visible. Just we need to do full screen. Yeah, it's fine. Sir.
Done?
Yeah.
Great. So the contours of the presentation is basically threefold, or rather four subparts. First is the introduction, where we'll try to run through what exactly when IBC started, the journey so far insofar as the insolvency regime is concerned, the process which is basically run by the insolvency resolution process, professional. And lastly, why it is important for us to manage to the extent we can as regards various stakeholders that we do have in our corporate system. So first, introduction. Insolvency and Bankruptcy Code was introduced in the year 2016, varying dates for various provisions of the code to be brought into force. And the objective was basically to consolidate and amend the insolvency laws, because prior to 2016, there was a host of legislation, state-related aspects, which came into picture insofar as insolvency proceedings of a corporate, or for that matter, an individual was concerned. So the individuals were governed by the presidency insolvency laws way back and redundant insofar as their provisions were concerned. And as far as the companies were concerned, they were regulated by the Companies Act itself, which obviously underwent a huge revamp with 2013 Companies Act. So, and this is also the phase where we had growing NPAs across the banking sector, the sector bleeding with most of the accounts in some of the sectors, particularly like infrastructure or a few service sectors, undergoing restructuring, over restructurings under the RBI frameworks, but nothing concrete happening insofar as the resolution of these accounts were concerned. So with that backdrop, the first was to consolidate and amend the insolvency laws to provide for reorganization and insolvency resolution of corporate persons, partnership firms, and individuals in a time-bound manner. Although I'd like to put in here that partnership firms and individuals provisions have not been notified in totality, barring the provisions in relation to corporate personal guarantees extended by individuals or firms in relation to the debt that was availed by a company. The other objectives were maximization of value of assets of such person by time-bound resolution and ensuring that there's continuity of business during the phase or during the period when insolvency is on, to promote entrepreneurship, availability of credit, and balancing the interest of all the stakeholders. And the significant change being compared to the erstwhile regime, government dues were not in the similar order of priority insofar as the payout to government departments is concerned. That was a significant shift from what the regime used to be prior to the introduction of IBC. Also, it provided for establishment of an Insolvency and Bankruptcy Board of India to oversee and regulate the overall processes, significantly to regulate the insolvency professionals, where now insolvency professionals are required to be registered with a IPA coupled with registration with IBBI, which gives them the professional opportunities to act as an insolvency professional. Since its enactment, the code has undergone many amendments. We'll not deal too much into it, and I don't want to cloud you people with legislative amendments. Rather, we'll be running through more of the practical aspects. While not everything can be covered in a presentation, but we'll try to work around each of the pointers that could be probably of some help while you are managing the stakeholders going forward. The significant amendments, apart from the legal intervention that happened because of certain inconsistencies or lacuna, or rather the feedback from the market while the process was on since 2016, have been twofold. One is prepackaged insolvency resolution process, which is a significant shift from a regular company insofar as it applies only to companies which are registered as an MSME. And from a process perspective, there have been some concessions granted to such entities where the existing promoters who are otherwise barred in a regular corporate from participating in the process. In case of a prepackaged insolvency resolution and where a company is an MSME, they are permitted to participate and give some kind of a plan for lenders to lend their support and allow the company to run with promoters still helming the affairs. The second significant development has been insolvency resolution framework and bankruptcy framework being notified for individuals and partnership firms, but to the limited extent being for those individuals or firms who are guarantors to corporate debtors, who had extended guarantee for the debts availed by the companies. So that's the basic backdrop. We'll now run through you a few data points which have been drawn from the insolvency and bankruptcy newsletters, IBBI newsletter, as late as June 2023, to give you an insight of how exactly it has shaped up since 2016 and why it is important for us to think twice before we plunge into action in seeking initiation, or for that matter, preventing initiation against us, the process of insolvency as such. So if you see, typically there are three classes of stakeholders who could initiate the process. FCs standing for financial creditors, OCs for operational creditors, and the CD means the corporate debtor itself. And if you look at it, typically financial creditors and operational creditors are almost on a similar footing insofar as the debts are concerned, and therefore significant chunk of initiation since inception of IBC has happened by FCs, or for that matter OCs. And corporate debtors initiating that process has been rare, but this is significant because it gives a relatively easier way to exit businesses, provided the company is otherwise solvent and capable of meeting its liabilities, insofar as the initiation by CD itself is concerned. Or for that matter, a situation where CD per se or the board of directors or the shareholders are of the view that, look, this business is no more worth pursuing, and therefore we'd like to exit it. So it could be either which ways. The second table is about the various corporate insolvency resolution processes that started. since inception of IBC, and where they have ended, or what it holds insofar as the current scenario is concerned. So if you look at it, out of 6,815 odd cases that have been initiated or admitted, 1,005, that's roughly around 15%, 12%, has been reviewed or settled. Then there is a option for the financial creditors to actually withdraw the petition, finding some solace in the overall affairs of the company or payments being made by the company, which leads to withdrawal under Section 12A. Thereafter, approval of resolution plan and commencement of liquidation. Now, if you look at it, commencement of liquidation is basically the last phase of the overall process. So just to give a brief insight before we move into the process per se, the overall insolvency process is bifurcated into two limbs for a company. First one being an attempt to resolve the entity by seeking resolution plans from interested parties, who are basically called the resolution applicants, who propose a revival plan, and if that's acceptable, probably it's approved by the committee of creditors, and thereafter the NCLT, which gets into the implementation phase. Should a resolution plan not be received, or having been received does not garner sufficient support from the committee of creditors, then it moves to a liquidation phase, which is basically an attempt to sell whatever is available in the company, recoup whatever is received out of such sale, and distribute amongst the stakeholders in a particular waterfall mechanism as stipulated under the code. So the first one is an attempt to revive, and the second, with the liquidation phase, is basically to wind it up and close the chapter in its entirety. So you could see that at least 1/3 of the cases that got admitted moved to the liquidation phase. And that is one of the prime reasons why it's important that when we are having business relationships across sectors or across jurisdiction, and within that with a differently positioned entities as regards their finances or as regards their performance, we should be cautious of our rights. We should be aware of when we should be initiating or how to handle that relationship before it reaches a stage where I'm tied insofar as initiating or participating in a particular process is concerned. And as we move forward, while we run through the process, you'll get to know that from an operational creditor perspective, how limited your role would be when you are seeing a stakeholder, a supplier, a vendor undergoing this process where you are helpless, not able to recoup, not able to participate, not able to know what exactly it holds for you. So the outcome of CIRPs, and this is where I'd like to spend just 2 extra minutes to make you understand what it means. So as we just discussed, that yielding resolution plans or liquidation. And if you look at those two numbers, which or rather last 4 rows, the two numbers which have been underlined, 34, 17.7, 643, 635. Similarly, CIRPs yielding liquidation 6.2, 9.3. This data point basically reflects that when a resolution plan, out of the entire resolution plans that got approved, the recovery for financial creditors stood at 34% of their admitted claims. For operational creditors, it was half of what financial creditors got, typically 17.7% of whatever they had. Similarly, when those set of companies which failed to get a resolution plan and were forced into liquidation, you see the fall in the realization. So the liquidation value as percentage of claims was 6.2%. And For operational creditors, it was 9.3%. So you could see how significantly the numbers have fallen. And typically it means that this is what they would have realized against whatever was due to them when the company was referred to the insolvency resolution process. That also means that there's significant amount of money that gets lost out when the process starts. And should you not be managing the relationships to recoup as much as you can prior to the initiation of these processes by any entity? Obviously, you can't control what others do with the set of stakeholders that you have, but you can definitely manage your recovery by initiating dialogue, trying to understand what best could be done to recoup before the process starts. Also relevant in the second row of the subheads is the average time that's taken. So if you look at it, average time taken for closure of CIRP is 643 and 635 days. And similarly for closure of CIR yielding liquidation has been 480 and 450. So roughly more than a year or year and a half gets spent out in this processes to yield whatever they do. And this is another limb where I'd like to just bring to the notice of the audience that the claims of an operational creditor, and I'm basically in the presentation I'll be focusing more on the operational creditor structure because I believe most of the participants would be representing those who have healthy business relationships, and some of them are confronting issues with recovery from their customers and so on and so forth, and really don't foresee too much or a significant adverse issues with their financial creditors or they being financial creditors on their own. So here, if you look at it, the liquidation value is the fourth column from the left. You'd see that financial debt owed to unsecured creditors is the only significant money that goes out from the system insofar as realization is concerned. And an operational creditors fall much, at least 2 levels below that, which technically means that with a waterfall mechanism, and this has been drawn from the same waterfall mechanism as is stipulated in the code, which leads to a scenario where unless the first one is paid out in its entirety, the second one gets nothing. And therefore, the recovery for operational creditors looks very tricky insofar as the liquidation process is concerned. This is a slide for the average process time, and typically what has been stipulated in the code is 180 days plus 90 days. But given the current infrastructure for managing the insolvency processes, and with due regards to the legal system around, 180 days or plus 90 days is next to sort of impossible in the current regime, at least. And most of the processes have at least consumed more than twice the stipulated period, at least. Some of them as good as 4 years, 5 years for now. So that's where we are insofar as the performance of the code is concerned. And therefore, it's important for us to see and not be driven only by what legal rights are available with us. Rather, take a conscious call on what's the timeline that gets spent, what's the management bandwidth that gets consumed, and what's the recovery eventually if insolvency resolution process is initiated. That's the backdrop. We'll get into the third phase. And we'll take maybe another 15 minutes to run through the next 3-4 slides to run you through what the overall process is and where an intervention from you, a timely intervention, would be of great help insofar as managing that situation is concerned. And thereafter, we'll try to touch base on some practical aspect of how you can or to what extent you can manage. So the corporate insolvency resolution initiation can happen by three set of stakeholders: financial creditors who represent the banks and financial institutions from whom a company has availed loans, resorted to borrowings, and basically any other arrangement where money is granted or borrowings is resorted to on the basis of time value of money, which typically means the interest bearing mobilization of funds. So all those classes would be treated as financial creditors who can initiate the process upon default. We'll get into the other criterion for initiating the process in the subsequent slide. So financial creditors is the first class, first set, and the initiation happens under Section 7 of the code. The second class of creditors would be the operational creditors, who basically can initiate if there are certain receivables from the company in respect of provision of goods or services, including employment related service, or a debt in respect of repayment of dues arising under any law, which is typically the statutory related aspect. Although statutory authorities have, as of now, not really taken keen interest in initiating insolvency processes for recovery of their dues. The third stakeholder is the company itself, but in this case, the criterion is different to initiate the process, which is basically that the company either does not have any debts, but it wants to close down. And the second is, even if debts are there, the assets of the company are sufficient enough to discharge that liability, and therefore the company and its shareholders have decided to shut down. That's how it's basically put in. The minimum amount of default, and will restrict it to financial creditor and operational creditor, for the process to be initiated is rupees 1 crore. This is a comparison of financial and operational creditor as to how or what triggers. So the first level is default in relation to financial debt or default in relation to an operational debt. The threshold being met, that is 1 crore. Application by financial creditor before NCLT. But in case of an operational creditor, there is yet another prerequisite, which is a demand notice. And we'll deal with it further, but this is one of the most important steps insofar as an operational creditor is concerned, which has worked wonders in some of the cases where a demand notice issued under IBC has actually led to settlements in as short as 15 days, 20 days time. And that's why it's important for us, if a debtor, to respond to demand notice appropriately and adequately covering everything that we have to say, failing which it would be a deemed acceptance of the liability. And if we are a creditor, we should initiate the process after serving a demand notice. That's a mandatory requirement. That's the first bit. And apart from that, when we are raking up or sending the demand notice, we should be ideally be clear about what were the contours of the overall contract, what led to, when the cause of action arose, was the quantum of debt that's due, and so on and so forth. The second bit is about ascertainment of existence or non-existence of default by NCLT. And in case of an operational creditor, when a demand notice is issued, the follow-up action expected from the debtor is either it has to showcase that there is a dispute in relation to the operational debt, and that dispute is subsisting as on the date of the demand notice. The other way of resolving it is to pay up and show that the repayment has been done. If these two are not fulfilled, it typically becomes a straight-through process for the operational creditor to file an application and seek initiation of the insolvency process. The last limb is about once the debt and the default has been established, then the operational aspects come in, where the NCLT as adjudicating authority basically verifies whether the application is complete, whether the insolvency resolution professional who is proposed to act as such is not having any disciplinary proceedings, and so on and so forth. Also, one important aspect for both the limbs is about an information utility. So information utility has been a baby of IBC itself, typically a creation of law insofar as mandate is concerned. They are mandated to maintain a record of the default, both on the financial as well as the operational side. While the court is silent as regards operational creditors' requirement to have an IU certification. Having said that, there has been a recent judgment by principal bench of NCLT, and thereafter most of the NCLTs are insisting that for an operational creditor to initiate the process, he should also procure an IU certificate as regards the debt and default. That's how it is positioned, and it's typically as good as a CERSAI registration or say ROC filing as regards charge, where the IU basically maintains the record of the transaction, financial debt or operational debt, the overall structure that was contractually agreed upon, and any security that was provided for due fulfillment of the obligations by the debtor. This is the process flow, and the last 3 pointers are what basically brings us to reconsider and review our processes, or rather rethink how we can manage, given the fact that the process initiation itself leads to a different scenario insofar as the data is concerned, and therefore it's important for us to understand the overall structure. So as we dealt with in the previous slide, it's the same. The first 4 pointers of 3 pointers are similar, or rather a repetition insofar as how the process starts and what it leads to. So existence of debt and default, dispute in relation to debt or default can actually prevent initiation, but how far it would be of help is a separate question and circumstantial. The third bit is once the application is held to be complete in all respects and there are no disciplinary proceedings, the application is admitted. And admission leads to appointment of insolvency interim resolution professional who takes over management and control of the corporate. The CD reference here is corporate data. Simultaneously with the commencement and appointment of IRP, the powers of the board of directors stand suspended, which typically means that in some of your cases, the persons whom you would have been dealing with all through your relationship are no more in authority because their powers have been suspended and somebody else has taken over the management and control of the CD, and who has to be regulated by the provisions of the code. And coupled with it, there's yet another agency which comes. It's called the Committee of Creditors. So the 3 important steps upon commencement are the last 3 pointers herein: the appointment of interim resolution professional, the suspension of the board of directors, and constitution of Committee of Creditors. I'd like also everybody to take note that Committee of Creditors, and I'm going with the assumption that you're not strictly into insolvency practice, and therefore you need to be aware what a committee of creditor means. So the committee of creditors comprises of only the financial creditors of that company, if there are any. And if there are no financial creditors, then the committee of creditors shall comprise of 18 largest operational creditors, along with a representative of the workman and a representative of the employee. Which means the decision making insofar as the process is concerned, which vests with committee of creditors and which guides the resolution professional during the entire process of insolvency resolution, is a position which you can hold only when you are a financial creditor, or is circumstantial when the company per se does not have any financial creditor and you happen to fall within the 18 largest operational creditors of that company. Very tricky and rare as well, unless you have significant exposure to that company. Here we'll try not to run through the entire bit of the process, but we'll try to draw your attention to the ones which have been underlined, which are the significant processes. So insolvency resolution commencement leads to the first step, or first what you call impediment insofar as we as creditors are concerned, which is declaration of moratorium. That's the basic premise on which the entire structure has been devised, that when the resolution process has kick-started, the company cannot be proceeded against by individual stakeholders, creditors, or employees, or government departments. And therefore, there's a complete ban or bar on initiation of any legal proceedings against the company, which means you will not be able to have any recourse to anything that is otherwise available under law, insofar as recovering your legitimate dues are concerned. The second important step, which calls for attention by everybody, is the declaration or the advertisement by the resolution professional seeking submission of claims. And we have, at least in our limited experience, we have seen that there are many companies who miss out on these deadlines because they either don't get the communication, or having gotten it, they don't really furnish the claims in time. And later on, when they realize they are behind schedule, or the process have moved much faster than they envisaged, and for their claims to be submitted even, they would need to refer it to NCLT, file an application, seek its direction for the resolution professional to accept your delayed submission of claims, condone the delay and accept the claims. Also be mindful, your claims admission is a process which may not really lead to recovery. Having said that, it definitely leads to an entitlement. That's the difference between, or rather, it's a process where you stake claim for whatever is due to you. Whether it eventually leads to recovery or not is something that is long drawn, circumstantial, and depends on the underlying value of that company. The other important thing is, once the claims have been filed with whatever has been called for as your submissions or the underlying documents, the resolution professional is mandated to consolidate the claims and put them under various buckets. The buckets being the financial creditor, the unsecured financial creditors, the operational creditors, the statutory dues, and so on and so forth. And that consolidation leads to the determination of what class of creditors are there across, and within that, who should be elevated to committee of creditors, so as to take significant decisions or give guidance about how the process is to run, including the parameters in which a resolution plan is being sought for from the market, from the interested parties. The next step is where an information memorandum is prepared. That's basically giving an overview of the company. Then you have resolution plans submitted by them, by the resolution applicants who are interested in taking over and resolving the company. And in this process, I'd like to also put in one word that when a resolution plan is submitted, the contours of the financial proposal is driven on two basic but critical criteria. First, whom I should be paying and for what I should be paying. A lot depends on what kind of charges, what kind of encumbrances have been created by the company in favor of their financial creditors or in favor of uh, any other stakeholder. That's first bit. Because for me to resolve a company, I would need to know, okay, what all I would require for this to run, and so on and so forth. The second is from an operational perspective, I'd still like to pay up. The court typically provides that you should be at least making payment to the extent of liquidation value, which is very, very minuscule compared to what outstanding of any creditor would be. But operational creditors are still paid. In some of the cases, we have seen as good as 100%. But that depends on the criticality of your supplies insofar as the operations of the company is concerned. So if you are a supplier or a, say, technical know-how provider for a very specific component of the overall manufacturing structure, probably you are better off and you can expect a better recovery within the resolution plan as well. Whatever plans are received is subject to verification from a perspective of compliance with the code and the financial or other parameters stipulated by the committee of creditors, which upon approval is placed before NCLT for its concurrence, and then it gets into the implementation zone where whatever was promised to be paid to each of the stakeholder gets paid as per the timeline stipulated therein, and the process ends there. In case the plan is not received or having been received is not approved by COC or for that matter by the NCLT, we move to the next phase of liquidation, where you're basically, the process hovers around only two significant steps, or rather three, since there is significant gap in the overall process structure from where we start commencement of insolvency to commencement of liquidation. The process of calling for claims is reinitiated. Then the asset memorandum is prepared, and then the decision is taken whether to sell the company as a going concern with all its assets and liabilities together, or whether to sell the company in bits and pieces, identifying the respective assets. Whichever way it is, the recovery is to be distributed as per Section 53 with a waterfall mechanism, and operational creditors at least fall last and just above the preference and equity shareholders of the company. So typically these three processes, the first is calling for the claims, thereafter the auction of assets, and then distribution. So with this backdrop that we had thus far, what exactly and why are we required to manage? So we are required to manage because moratorium kickstarts upon commencement of insolvency proceedings, which means you as a creditor will not be able to initiate any legal proceedings against the company which owes you an amount, and an amount that's significant enough. Secondly, if you are not part of the COC, which has been the case in most of the insolvency processes, you would not be able to have any say in the insolvency process or decision making, except where you have initiated the process, and having initiated, you are out of the committee of creditors because you don't qualify. And therefore, you don't know what's happening around. We also saw that the process entails long drawn litigation or market driven substructures, because of which the value depletes and depletes fast, and therefore the recovery is insignificant. In case of technical collaboration structures where you are a party, where your job is only to provide a technical support, you might lose business. And therefore, it's ideal for you to be either scouting for a new partner or looking for other business opportunities or exiting if that's the case. In case of JV company, where probably you are not controlling the affairs, but you have otherwise invested, there could be a potential risk to the loss of investment. And in case any of your directors had extended a personal guarantee for any of the portfolio entities, and that entity is subject to insolvency proceedings, then you also run the risk of reputation and the directors facing other consequences, not only in the entity that hurts you, but also in any other entities where they are associated as directors. So these are broad areas which calls for intervention. Now, these are the broad heads under which we have tried to identify financial creditors. Very limited say, because again, just to reiterate, I understand you are financially diligent, so you are taking care of all your financial creditors. Operational creditors is something that we'll dwell with a lot more and touch upon shareholders, joint venture company, investee entities, and lastly, the directors. I'll just pass through this and move to the first. So if you are a debtor, what you should be doing is you should have an eye on definitely the limit of INR 1 crore, which is the initiating structure. So anybody to whom you owe an amount of 1 crore or more needs to be managed and needs to be managed well, so that you are not on the brink of being admitted. And here, insofar as a financial creditor is concerned, you have a contract where the repayment and everything has been taken care of and contractually provided for. Hardly any difference of opinion insofar as the appropriation of amounts paid is concerned, but nevertheless calls for timely payments and you are not at default. And secondly, the reconciliation of books also. And in case there is a expected delinquency, you should be diligent enough to be seeking change in terms of finance or restructuring in time, so that the overall process is managed before you headed towards a structure which is not ideal to be there. Operational creditors. So what you should be looking at is robust terms of purchase of work order as regards quality, inspection, and acceptance of goods and services. Here, what typically, and again, I'll go back to where we had paused for a moment to understand demand notice. So demand notice, when it is served by a operational creditor, your recourse is to actually indicate as a response that, look, you are made supplies, but there were issues with the quality, or the process that was to be followed for your bill to be processed has not been completed, subject to inspection, or the inspection having led to certain discrepancies in the goods offered, or the services, the workmanship not up to the mark, and so on and so forth. And therefore, your recourse is dependent on purchase order or the terms of the work order. Significantly, your purchase orders and work orders should be so drafted as to provide for everything that comes to your rescue insofar as acceptance of the structure is concerned. Quantum of outstanding, and this is one gray area. Some of the purchase orders and work orders did provide for the interest related aspect. Upon default, what would be the interest payable to the operational creditor for the amounts due? This has been laid to rest with a host of judgments, and now your 1 crore does not necessarily mean the principal amount only, which used to be a recourse that was available earlier. Now it is settled that if the purchase order or work order provides that upon delay, the creditor or the supplier would be entitled to interest, then they can jolly well provide that, treat it as an amount under default, the interest component, and that takes away, say, a 75 lakh outstanding to a good 1 crore plus, which gives them the levy to initiate the process. So one needs to be mindful of whether or not to provide for interest component otherwise within the structure of your work orders. The process also calls for that in case you have been lackadaisical or otherwise not in the framework of initiating legal proceedings or raking up disputes, which you are otherwise positioned to do, then you should start having robust systems in place to ensure that if the supplies are not up to the mark, if the services are deficient, you have proper communication to this effect, and don't wait for a demand notice to be served. Have it in place. Whether it leads to a logical conclusion or not is a separate issue, but please ensure that your systems red flag and you actually have a proper communication in place indicating that this is a gray or this is a dispute as regards the goods or deficiency in services. The other aspect is about MSME status of the creditor, where whomsoever you have been dealing on the services side or on the procurement side, please have your systems or vendor registrations compliant enough to understand who within that bucket are MSME registered, because apart from insolvency regime, MSME is differently positioned because the MSME Development Act itself provides for interest to be paid for any delays beyond the stipulated timelines. And that MSME per se is on a separate footing. And ideally, you should be aware of who among the creditor lot belongs to this category for you to be exercising diligence. Also, be mindful that when a creditor is registered with MSME, they have additional right to refer it to their facilitation council, which is a body within the MSME Development Act. And there you don't have the luxury even of engaging with any council. You would have to represent on your own. And again, the issue boils down to the fact that whether there were any discrepancies or deficiencies, whether it was notified, and so on and so forth. Then the next limb is of managing is to respond to demand notices. Whenever a demand notice under IBC comes in, you have a timeline of 10 days to respond. And at the cost of reiteration, you should either be in a position to say that this amount claimed is under dispute, or you should be prepared to pay up. If neither of this is taken care of, probably the operational creditor is well positioned to initiate the process at any point of time thereafter. And with the above backdrop, wherever possible and wherever your financial intelligence showcases that it's not worth, then please settle it out at the earliest before they initiate the process of insolvency. We'll move to the next, where you are a creditor. Typically, this is only to ensure that you are rightly positioned insofar as initiating the processes are concerned. And this has been drawn from where or what commencement of your application calls for insofar as commencement of insolvency proceedings is concerned. So if you're a financial creditor, be mindful of having registration of charge being done if there's any encumbrance that you have sought in your favor. Information utility, record of default, debt, default, and charge to be recorded, because these are mandatory prerequisites if you have to initiate. If you're an operational creditor and you have long-standing dues with somebody, obviously the books of accounts have to be consistent with the terms of the contractual arrangement. Again, the same holds good. If you don't want, or rather, if your purchase order and work order does not provide for an interest component, while you can include it, but that's debatable. And if the quantum of amount due exceeds 1 crore only because of the interest, then the initiation itself can be challenged. So you have certain aspects to be taken care of from a perspective of the purchase order, from the perspective of your work orders, or if you are an MSME register, probably you can have recourse to that support. So your books of accounts and your outstanding should be consistent with whatever contractual arrangement is there. Typically, the issues that come in about the retention related aspects, about the advances recovery, or about the GST implications and so on and so forth, which needs to be taken care of on real-time basis so that your books are reflective of the correct and the agreed understanding as regards the claims, counterclaims across the or in relation to the said work order. Again, information utility, as I indicated, while it's not mandatory for the operational creditor, of late it is important and desirable to have this in place, at least in cases where you intend to initiate the proceedings. And lastly, the intervention that is sought, good governance requires that you please follow up on or have a clear understanding of what's happening around with your debtors and ensure that you are compliant in filing your claims with sufficient document and supporting as regards the computation there. Investment and other arrangements are tried to cover as much as possible from a general understanding, but typically this is circumstantial depending on what kind of arrangement you are having. So one thing that definitely comes to our mind is this, that all your arrangements as regards investment, technical collaboration, or exclusive sales arrangement, or anything on those lines, which has a significant business exposure insofar as you are concerned, should have an enabler to exit that arrangement if insolvency gets triggered. You should not end up in a scenario where you are an essential service provider for that company and end up supplying not having the clarity of when and to what extent you will be paid. So enabler is most important aspect from a arrangement perspective, commercially otherwise. If you have an investee entity, you should, and even if you're not in control of that entity, but say that is headed towards a insolvency process, eventually it leads to a situation where the stake of that company in your investee entity, or say the investee entity per se, is sold out if the resolution plan is approved. If not, the assets are sold out. Whichever way it is, it calls for analysis of the underlying asset, and if you find merit, take a conscious call to either buy or be bought out. In time helps. And in cases where you are a minority stakeholder, and assuming you have a JV company where you are 30% and somebody else is 70%, and that 70% entity is undergoing insolvency process, then typically that could lead to that 70% being offloaded in favor of somebody else who might be your competitor. Not sure how you work around it, but it calls for either exiting, or if you find value in that company, prepare yourself to buy out that 70 and be out of it. The other way of handling a similar situation could be being a matchmaker where you mobilize someone who could be interested in the overall entity and reduce your exposure, which means either you mobilize somebody who buys out that 70, and that guy happens to be an entity of your liking. If your arrangement is purely on the technical side and stuff like that, and the risk that you run is only about your operations, then looking out for alternative commercial arrangements where your significant exposure to the Indian market or to the said industry can be managed, then time being on your side, you should be initiating that process so that you are out of the existing arrangement, which is headed towards insolvency. And you can have a trigger point within your systems where typically a continuous delay month on month should trigger an overall understanding of that stakeholder, that's supplier or that service recipient or whosoever it is. Your system should permit or should rather have an enabler where the top management is aware that, look, these are the clients, these are the service recipients who have been dilly-dallying the payments for quite some time, or there is a market intelligence that they are defaulted on their financial commitments and so on and so forth. And one thing that I wanted to also bring at the same time is this, that ibbi.gov.in is a beautiful website insofar as understanding various corporate processes are concerned, not only from the perspective who your suppliers are or who might be undergoing the insolvency process, but also to understand and have a market intelligence as regards what's happening in certain sectors, identified companies, and so on and so forth. And that also gives you a indication of which process is under what stage, who is the concerned resolution professional, and so on and so forth. Lastly, if you have a stakeholder which is undergoing that process and investment or other arrangements have to be managed, please don't feel shy and have a continuous dialogue and engagement with the insolvency professional. The details would get communicated the moment you have intimation about that stakeholders undergoing any insolvency process. Directors undergoing insolvency proceedings, again, restricted only when a person who is a director had extended a personal guarantee, that guarantee being invoked and remaining unfulfilled. And that's the trigger point. The impact is this, drawn from the Companies Act, that any person who is an undischarged insolvent or has applied to be adjudicated as an insolvent, and such application is impending before the concerned authority, then he or she shall stand disqualified to be a director of any company. Any company essentially means you have somebody who is a professional director but had extended personal guarantee in some other cases, and there being a default, he having unfulfilled his personal guarantee obligations can trigger his disqualification in your company as well. Similarly, you have somebody who is with an industry face roped in as a director of your company, or your promoter being on board of some other company where you are an investor, and personal insolvency being initiated or a demand notice remaining unfulfilled will lead to incurrence or disqualification. And undischarged insolvent, that's defined or rather drawn. And I'll just take 2 minutes to brief you. While personally I'm not convinced, but this is a fact of life that some of the resolution professionals in these days have been taking different positions as regards the incurrence of disqualification. And that's why it is quite possible that the director incurs disqualification, which is legally not tenable. But then that's a fact of life that you will need to manage it then and there. If your nominee director has incurred disqualification, how do you go about it? Timely intervention, again, the same thing. You would have to also check on where all this gentleman or your representative has been as director, and see where all it is critical for you to have your nomination in place. The second thing that's important is, since the incurrence of disqualification is also tagged with the appointment or reappointment under the Companies Act, you can probably play around by trying to understand whether your directorship is on a rotational or non-rotational structure. Rotational comes only when the company in which the directorship is held is a public limited company. You can also think through the different insolvency processes on for the individual. You should ideally be having a discussion with the concern to understand what's the plan for him or her to be settling it out, and to what extent they are confident that their plans would be, in terms of settlement with a financial creditor, is likely to succeed. Lastly, no option being there, seek substitution wherever it's important that you have a board representation commensurate with your investment portfolio. That's it from my side. Happy to have the questions.
Thank you, sir. Thank you so much for such a detailed presentation and so much information, actually, a very comprehensive presentation. I think all members and our guests will get benefit out of it. So I request all our members and guests to kindly post your question in the Q&A box, please. Members, if they have any query or if they have any question that they like to ask to the speaker, then kindly post your questions in the chat box. And just to inform everyone that we'll be sharing the presentation with all of you with the details of Mr. Arun, Mr. Y. Srinivas Arun. And if you require any professional help, you can contact the team. You can contact Arunji for the same. And yeah,
So Shikha, I have one question posed by Mr. Mohan Jairaman.
Yes, sir.
So what happens when a minority shareholder is declared insolvent? So typically when a minority shareholder is declared insolvent, and assuming, Mr. Mohan, that that particular insolvent is a company, then the first step is resolution process, where the investment portfolio, being a minority shareholder, also forms part of the asset memorandum, or rather the company takeover process. And typically it's a change in the promoter structure itself. Assuming the minority shareholder is a individual undergoing insolvency process, so probably that would lead to offloading the percentage stake in this company and the money being used for repayment of their obligation.
Right, sir. Any other question? If you have, please post in Q&A or chat box. And we'll be sharing the details of the firm, Dental Legal, and also we'll share details of Mr. Y. Srinivas Arun, so that if you like to directly ask something, you can send an email or contact him through through call, or you can ask your queries. And any other questions? So we can put stop sharing for the PPT.
Yeah, I'm doing it.
Right. So I think it was very detailed, and you explained so well that as of now there is no more questions. And in case, I think some members, if they like to directly ask something, then they can contact you. We will
Sure.
share the information and everything. So with concluding this session, I